Hi, this is Jan Carosa, and today I am delighted to have legal expert Layne Lyons with me. One of the topics that I wanted to talk about for a long time are all the agreements that entrepreneurs need to have in place. I can't even imagine the stress, the cost in time and money when things go wrong that you could have planned for, you could have prevented it. And every entrepreneur should know what Layne's got to share with us today. But let me just start off a little introduction. Layne is a graduate of the Duke Law School, and she's helped women specifically for over 25 years. You can correct me on what the latest number is on there, but I'm just so
28, 28.
pleased. Yeah. So welcome, Layne. Um,
Thanks for
when
having me.
This topic is so important for entrepreneurs. You cover trademarks, you cover all the legal agreements that these people need, whether they're coaches, consultants, podcasters, authors. They all need to have these arrangements taken care of before something happens. So, Layne, maybe you can start with the story that inspired you to go into this niche and people
Yeah,
get an
absolutely. I would
understanding.
love to. Yeah, and course creators too, right? If you've got a
Yeah.
course, you need to get this, you need to get it buttoned up. But yeah, but we'll get to that. So I was not intending to focus my business on helping business owners, helping other entrepreneurs. I was doing my own business in a law firm, doing my own thing. And this is many years ago. I got approached by another entrepreneur and she said, let's get into this collaboration together, kind of like a joint venture. And, even though I'm a lawyer and I should have known better, I went into that working arrangement with her with no written agreement. I mean, look, I know why I did it, right? All the same reason I hear from all of my clients. Well, it was so friendly. It was aligned. Why lawyer up? Like, right? Like, why make it like cold and kind of unfriendly? So I know why I did it, but I'm sure you can guess what happened, right? I got completely burned. I can't say that she's like stole or swiped the content because we were creating it together on in a big Google Drive folder. So we were sharing it, but there was an understanding, an agreement between us. Just we're working together for a year. So I lost all of the content that I had been creating. She went and she published her own version of things. I lost all of the content, all of the money, and so think about so much time, right? All of the money that I had invested into the endeavor. And really the biggest thing was all of the money that I was going to get, those future earnings that were going to come out of the collaboration. And because I had no written agreement, there was really nothing I could do about it. It was just one person's word against another. So for anybody who knows me for a while knows that I don't sit for very long and wallow. I might I think I shed a couple of tears and I was like, what? Did that really just happen? I kind of had like a weird hunch for like a couple of weeks. And then I could see that the writing was clear on the wall, but I didn't sit for very long in it. What I did was I grabbed my laptop, right? A couple laptops ago, not the one I'm on right now. I grabbed my laptop, right? Technology. And I started drafting the exact agreement that I wished I would have had with her, like all the different parts and paragraphs that I would have needed to protect my content, my money, my time, our relationship together, everything that I
Your
would have needed,
future.
my future, my sanity. Oh my gosh, right? So everything that I would have needed to protect myself. And that made me feel a lot better. And when I finished that, I started drafting all of the contracts. I just started thinking like, what are all the contracts that I wasn't really having an online business, right? So, but what are all the contracts that an online business owner needs to keep themselves safe? What do they need? And so I drafted up this big suite of agreements. And then I started reaching out to all my, my business besties, right? My biz BFFs and saying like, what are you using for contracts? And the answer I got back from every single one of them was the same. Wait, do we need contracts?
Oh my God.
What contracts? I don't have contracts. Do you have a contract for me? I don't even know what you mean. There was just this, I think, I think it comes from, we spend so much time creating all of the things, but we don't spend enough time protecting those things. And I was like, right then and there, I was like, I need to help people do better. I need to help women specifically. That's really where my niche is, although we have several amazing token men clients in the practice. But really, like, I can't just, now that I saw it, I couldn't unsee it, right? It happened to me. So I got to see firsthand exactly how terrible and devastating it not only threw off that side hustle that we were doing together, it really for a while kind of threw my whole business into a tailspin because it's just pervasive, right?
Well, it sets you back, right? It's for every, you try to go a step forward. Now you, not only the financial, the time, the trouble, the emotional distress of the loss, right? You've been betrayed. You've been, I mean, that's hard to get over, right? It's more than, it's a bigger cost. So we want entrepreneurs to think about these things, and they can avoid this financial time cost, emotional cost,
all the drama, right?
And the setbacks, right? Because it's going to take you more time to recreate everything. So one of the big things that you do, and I want to make sure that we cover this early on, is talking about trademarks. I've got my own trademark story to tell. The company I worked for at one point got a letter from Time Life saying, you do not have the rights to your company name, which had the word time in it. And they were a media company, but that's as close as it got to what Time Life did. But still, because of this, they had to recreate the wheel, stop everything, rename the company, rename everything. And it starts to bite into your credibility, your reputation. What do you mean you're changing your name? That sounds fishy, right? So because you didn't do things right at the get-go, talk about trademark, what it is, the importance of coming together with the research to do the right name and then to protect it.
Yeah, absolutely. Absolutely. And trademarks, when we're talking about contracts, which we're going to dive into a little bit, that's about protecting your business as a whole. Trademarks are about protecting your brand, right? And you mentioned that you had that media company, or you worked for that media company. That's a brand. So when we're talking about trademarks, we're talking about protecting that brand, that you're out there being visible, getting known, like whether that is the name of your course, the name of your podcast, the name of your entire company. Maybe it's your logo, maybe it's your tagline, but it's about what folks, I like to explain a trademark like this is a shortcut for folks to know that the product, whether that's a physical product like goods or a services that they're buying, that's coming from you, from your brand. So when we see the golden arches, we know immediately that's, whether we see that on a billboard, in a movie, on a wrapper, in a commercial, we know immediately that's McDonald's. When we see the little green mermaid on a cup, we know right away that that's from Starbucks. Or the Nike swoosh. We don't even need to see the word Nike anymore. We just see the swoosh. We know that that's from Nike. And what's important is we're able to expect when we know it's coming from Nike, we've got a certain expectation of what that product is going to be. Same as with a course, same as with a podcast, right? If it's Nike and I buy a tennis skirt and it's got the little swoosh on it, I know it's going to be moisture wicking, good quality fabrics, right?
So you know what to expect from the brand.
Right. I know what I'm buying.
So it's always associated, even when you give your business card, it's like, oh, you work for the brand. I know. So you must be okay because I know that brand. That association becomes critical because you put so much into building it. So it's important to protect it.
Yeah. And to your point, I think a lot of people think that the value in trademarks is I'm going to get my name trademarked or my logo or my my brand identity. I'm going to get my name trademarked. And then I'm going to be able to stop other people from using a name that's similar to mine. I really think that the real value in having your name trademarked speaks exactly to your experience that you were mentioning, because to me, after doing this for so long, the real value in having your name trademarked is that you know that it's yours. You own those words. You own that name in related to what you're doing, related to what you're putting out, right? They were a media company. They would own that name relating to all media. And what's so important about that is nobody can just swoop in with a random, you open your email or you open your mailbox to a super aggressive, like, oh my God, the worst cease and desist letter that tells you that you have to, not you, but what did happen to you, did happen to your company. They have to take everything down, stop all business, right? Take everything down, scrub the internet today. Like if you had to take down every single Instagram post that had that name on it, I have clients all the time who come to me after the fact, of course, and they have to take down every single slide. They like have a course or they have 3 courses. They got to re-record all of the materials if they had the name behind them. If they've got reels on Instagram where they've got the name or they have the product placement, they have to
start a whole new social media account.
Everything. And the whole time it's down. You're under threat, right? Because most lawyers are going to give you 3 days to get everything down, to take everything off the internet. So you're under duress, you're under threat, and you're not earning any revenue. Take it all down, start all over again, and then somehow hope that your audience is going to follow you to the new name. And what we see is about 25% of audiences follow with a new name, which is a big hit for a company that can be devastating.
Can you imagine? Yeah, it is devastating.
I see it all the time, unfortunately.
What are a couple of things that people can do to get, okay, I need to do something. They need to call you, and then you walk them through the steps to do that.
Yeah. So you need to have a trademark attorney. There's just these amazing statistics about how when you this is not an area of the law that you can DIY. I will always tell you, you can DIY that. Like you get a splinter in the bottom of your foot, you take that out yourself. You get a splinter in your child's foot, you take that out yourself. Your child has a wound or an eye surgery, an eye issue, you need to go to an expert. Trademarking is one of those areas in your business, one of those areas in the law. It is incredibly intricate, and sometimes you get what you pay for. So
you could try to do it, but you would not have done everything you needed to do. And that's going to cost you as much as if you'd done nothing. So it's important.
So we have a call. We talk about your trademark. I let you know about any immediate red flags that I see with it.
Thank you.
And then I give materials. We have an explanation. I really make things, and I'm big on analogies. So really making it really clear about what are the steps. And trademarking is a 12 to 15 month process right now, 12 to 15 months. So there's a lot of things that come up along the way. There's a lot of correspondence with the attorney in Washington, D.C. at the trademark office. People don't know how to answer those letters. People don't know how to argue for themselves. People don't know how to respond to that correspondence. So you need somebody who's going to do all of that for you. So we handle absolutely everything so that I get the correspondence from the other attorney. I pick up the phone because, I'm old school, right? I've been practicing 28 years. Like I'm a phone caller. I pick up the phone. I get that young attorney on the line, and we talk it through. And then I call the client and say, this is what's happening, and digest it so that a client can understand, rather than a client trying to figure it out on their own. I can't tell you how many botched applications every single week. We get applications that came from big box legal of people trying to do it themselves or trying to go, the $6.99 route, and sometimes I can fix them and sometimes I can't.
I love the way that you've gone to so much trouble to make it understandable for the every person, right? Because it does seem like gobbledygook. It does seem scary. It does seem way above our heads. But from everything I've read about you, from everything I've listened to in other podcast episodes you've been in, it just sounds like you have a wonderful way of dumbing it down for those of us who are
Yeah.
are clueless. We know we need to help, but we need someone like you to guide us through it.
Yeah.
Let's talk about, you came up with this wonderful concept of a legal umbrella, and some of the pieces of that really, we can talk about a few of those in the time that we have, and then we'll kind of go through what's all included in the whole thing so that
Yeah.
people get an understanding of the breadth of what needs to be protected and how the pieces all come together. So some of the things that we talked about were that one-to-one client agreement.
Yeah.
And one of the things that people can all relate to is that a lot of entrepreneurs are asked to become a speaker. And so when you become a speaker, you need some kind, and people don't think that you might need an agreement, but there are reasons for that. So we'll talk over the one-to-one client agreement, why that's so important for your business, and probably a cornerstone, I would think, of your legal umbrella for any arrangement. So take it away from there about that.
For sure. You got it. You got it. I'm happy to. So first of all, it's called the legal umbrella because, of course, you know, umbrellas save you from getting soaking wet or from drowning, you know, your business going underwater, but also because each of the letters in the word umbrella stand for the things that you have to protect in your business. So U is for your unique content. M is for your money. B is for your brand, right? We were just talking about that trademark brand protection. R is for your relationships. E is for your e-presence, or everywhere you show up online, all your socials, all of that, right? And then LLA is your love life attitude. And this is really that sanity, that drama we were talking about. And so many of the contracts that you need in your business are about drama proofing it. So we've got this concept of umbrella with the 6 things that you really need to dive in and protect in your business. And nowhere is that more comprehensive than in a one-to-one client agreement. Because when you are in a one-to-one client agreement, or a client relationship with somebody, or, you know, it's really the same if you're doing a course, right? So we've got, let me slow down and just set the stage a tiny bit. We've got 2 different kinds of agreements, really, when we're working with others in a capacity like where we're serving them. So we've got one-to-one clients, and then and that's for a one-to-one client agreement. And then we've got another agreement that's called a terms of use. And this is for what I'm going to talk about them in conjunction. So I just wanted to introduce them. So your terms of use is when you've got a group program, an online course, a digital download, an evergreen product, something that's more of a hands-off purchase. With a one-to-one agreement, it's appropriate to get that signature at the bottom. With a terms of use, covers a lot of the same things, but really specialized for a more hands-off transaction.
A membership or a group, a Facebook group, that kind of thing?
Sort of, yeah. Yeah,
As well as
a membership has its own kind of interesting animal because a membership often has recurring payments. But let's say that somebody's buying your course with that's $1,000 course, and they're just going to make one single payment and they're just going to buy your course. Or if they split it up into a payment plan, that's not a monthly payment, right? That's a payment plan for that one purchase. So we've got that terms of use. So what do we need? And both of those, I bring them up at the same time because they're both your contracts where you're going to be serving your audience. So I just wanted to kind of create maybe a parallel between them. All right. So what needs to be in a one-on-one agreement and in this terms of use when you're writing a course for somebody or running a group program? Because it doesn't just have to be one-on-one clients. It's anything that's a client agreement, really. You've got, first of all, you're going to be sharing your content with them. So you've got your content that you've created, curated, and you're going to present to them. So what's really important in that agreement is to be able to say, look, you've got the right as a member of my course or as a one-to-one client. Hang on one second. You've got the right to use that content, to view it, to use it for your business one time. You do not have the right to take it and copy it, package it, and sell it as your own, which we see all the time. We see courses being swiped, rebranded, or even just slightly rebranded, and then sold from former students, former members, former clients. We see that all the time. So we've got to have something that's really firm language that says, yes, you have the right to view what happens to this content, right? I'm going to share all my best, juiciest content with you as a client. What needs to happen? What can happen? What are you permitted to do? And what are you not permitted to do with any of that content, whether that's PDFs, modules, trainings, videos. Okay. So that's your content. When you're in a one-to-one relationship with somebody, or they're taking your course, there's money. Money is going to be changing hands. And when it comes to money, we've really got two kinds of policies that we need when it comes to money. We need policies for when the money comes into our business, and we need policies for when the money tries to leak out of our business. So that's refunds, chargebacks, ghosted payment plans. We need to have really clear, I always say a serious business has serious money policies, because we can't just wing it when it comes to money. So we've got to make sure in our contract that we're covering all of the different things that are going to happen around money. And what are we, right?
I'm learning some things new too. So this is
good. Oh, good.
This is so impressive. I really think people need to kind of buckle down. There are so many people doing courses and not thinking about these things. It's just incredible. So let's do one more. We'll talk about how all of these entrepreneurs, course creators, podcasters, bloggers, they all do testimonials. They ask for them, they collect them. One of the things that you offer in this legal umbrella is that testimonial ability to collect it and then get that permission.
So this did not used to be part, and I do want to circle back to the speaker question, which you asked, which I just want to touch quickly on that for folks who want to get into that professional speaking world. But testimonials, and I'll touch briefly on that so that we can save some time for the next question. So testimonial release did not used to be part of the legal umbrella, and it came because a client got completely burned, and it like opened my eyes to like, wow, every business does really need to get a release. She had a brochure. She was doing a talk to a health coach, and she was doing a talk in Whole Foods. And there she was, she printed up 100 copies, back in the day of trifold brochures. She's there, she printed it up. She's so excited. And she printed it in the trifold on the back of the brochure, a testimonial. Of course, we've got websites now, but a testimonial from a client, local client, and printed the testimonial and the woman's name and the little picture where the woman had said, sure, use my testimonial. No, verbally, right? In a session, no problem. Well, now we got 100 printed copies, and the coach the entrepreneur is just about to go and do her first talk ever at Whole Foods. The client shows up to show her support, sitting in the chairs there at Whole Foods when Whole Foods used to do like lunch and learns, flipping through the brochure and sees her name and flips out. I didn't give you permission. You can't use this. And of course, then the client just, completely botched the talk, right? Of course.
Yes.
Heart pounding, right? Her heart, I'm sure, was just like this. So what we want to do is we want to, again, drama proof, right? That LLA, that love life attitude. We want to keep things sane and on track. We want to, if we're going to use words that somebody has given us, whether it's with their name, with just their initials, but it's their words, we want permission. We want written, signed permission. And it's real easy. Everything's real friendly. At least everything, all of my contracts are very fair, very balanced, very friendly. And then you just have a nice folder on your desktop of all your signed releases when and you just squirreling them away. Should you ever need it, you've got it. It's all about being proactive.
Protect yourself.
Protect yourself.
This, and I know, talk about the speaker arrangement for a minute, and then let's cover a little bit about what's included in the legal umbrella, and then we'll let people know how to reach you.
Sure, absolutely. Speaker agreement. So when you are speaking, there's really two kinds of speaking. One, when you're going to be the professional speaker yourself.
Yeah.
And what I love to see, what I highly recommend is that when you are going to do paid professional speaking, you have a written agreement that you bring along with you so that everybody's on the same page, so that everybody, again, it all comes down to those failed expectations, so that everybody knows, are you being paid? How much are you being paid? Who's paying for the travel? If there's travel involved, what are your audio visual requirements? Even if it's on Zoom, maybe you need to have a moderator to be able to answer the questions. If it's on a stage, maybe you need a headset and a microphone and a stool and water, and maybe you need to have a tech check so that everybody, and a really big one that goes wrong here is who owns the recording? Who owns the
permission? Yeah.
Who has permission to use it? Do you have the right? Do they have the right?
Right.
So that's all about your professional speaker agreement. The other kind of speaking that folks do is when they have a platform like a podcast and they invite guests onto their show. Again, it's a completely different animal, different beast. We need to have an agreement that spells out who's doing what. Certainly most podcasts are not paid. We want to make that clear in writing that there's going to be no compensation. Are there promotional requirements? Like, as a podcast guest, do I need to share this with my list? Do I need to send
this? This is so critical. So often they go into these joint venture partnerships and they do or don't promote to help each other. But there may have been a discussion, but nobody ever gets around to do anything. And there's a lot of disappointment. And then you get these relationships that are harmed because one or the other didn't pull up their end. So you're right. Putting it in writing kind of makes everything rosy. Everybody knows what's expected of them and they can move forward with that. So yes, that's really an important point. So let's go through the complete group of what's in the umbrella. I'm doing this like umbrella.
I love it.
You want to protect everything. So you think about the one-on-one client arrangement agreement that you have. We talk about the site disclaimer, and I love that you do the many disclaimer, because we have so many different uses of our materials. Whatever kind of collateral that we're doing, it's important to have different shorter versions of something that kind of let everyone know that you're on the up and up and here's what we expect. And then beyond that, you can let's go into the next ones that are in the package of the umbrella.
Yeah, absolutely. So you've got your privacy policy. This is a mandatory document that everybody must have on their website. So if you're collecting any information like a name and a first name and an email address in exchange for an opt-in, or if you've got a contact me page, anything on your website where you're collecting any information, you have to let folks know how you're using that information, how you're storing it, who you're sharing it with, and how they can opt out if they want. It's very, very strict requirements that make you this is a mandatory legal document. We don't have time, but there are big fines if you don't have it.
Yes.
So this one is like a no-brainer. We just want to make sure that we have that on there.
And that it's complete, right? So some people even go back and review it each year to make sure that it's still covering everything that they want. Okay, absolutely. So then we know that the terms of use that you talked about, the testimonials that you talked about.
We've got a website terms and conditions. This is really different. Don't get this mixed up with the terms of use, which is for your clients, right? A terms and conditions is kind of like the monopoly rules for your website. You know, when you're playing Monopoly with your brother-in-law and he says, you only collect $200 the first time you pass go. And you're like, I think you collect $200 every time you pass go. And he's like, nuh-uh. And you're like, what do? You go to the box. You take out the box and you read the rules. And turns out he's wrong. And you read the rules. Well, your website terms and conditions are the monopoly rules of your website. And if there is ever any issue, like, for example, stolen content.
That's exactly what I was thinking of, the swiped content. Only because it happened to you, but because it happens to a lot of content creators.
Definitely. And that terms and conditions
They get it. They understand.
Right? It has these clauses in these paragraphs inside that terms and conditions that if there is ever any kind of swipe content, we're going to present that to whoever, like the arbitrator or the judge. They're going to go to the box. They're going to go to the terms and conditions. It's kind of hard to say, I put folks on notice that the content was all mine and that, we don't allow any copying. If you didn't do that, you can't really say I put folks on notice. So that website terms and conditions is that safeguard. It basically puts like a fence around your business and makes doing business so much safer. Right. So we talked about the disclaimers. And again, a disclaimer is just protecting you from someone using your materials, having a bad result, and coming back to blame you for that result. Right. So it says, I'm not responsible for the following, right? Working with me is not a guarantee of future earnings, right? So we've got the disclaimer, we've got the mini and the mini disclaimer, because I never want anyone to say, oh, it was too long, I couldn't put it on there. So I give you two versions, which is a paragraph and then one that's just 3 sentences. So you can put it on the bottom of your emails. You can put it on your socials, in your link tree, or on your slides, or if you're going to do a presentation. So you've got that all tidied up. We've got the
payment plan, the credit card authorization plans are both about money and
about
how
money, right?
You're doing it right.
Then we said the testimonial release, and the last one is a media release or a live event release. Yes. So we're recording this on Zoom. So if you work with any clients over any kind of media, you want to take photographs at a live event, or you want to record any Zoom sessions, or you've got a group program or a course and you're recording the live sessions so that anyone who couldn't attend is going to see it later, you need to have permission. We need permission.
So the way that people can find you is LayneLyons.com, and that's LayneLyons.com. It's going to be in the show notes. She's got a free checklist of the 10 things in the umbrella that we just talked about, so that you can catch that. That will be in the show notes as well. We want to make sure that you start to follow her. She's got a wonderful newsletter to subscribe to, and believe me, it's so worth it. And I hope that entrepreneurs will understand these are a lot of the things they should touch on, that touches their heart, that they understand. I need to protect my course, my podcast, all my content that I create, and I need somebody like Layne to help me do that.
Totally. Yeah. And you know what? We're also going to give a gift of an intellectual property inventory, so that folks who were hearing about the trademarks and thinking, I might need to get started, this is going to be a little inventory to help them, not a little, it's an inventory to help them kind of do a guided review of their business and see what intellectual property do I have. So happy to share that as well.
Thank you. Again, we'll put that in the show notes, and you can find Layne at her site. Thank you, Layne, so much. I've been looking forward to it. It's an important topic every entrepreneur needs to work on, and take the time, block it out, and protect yourself.
Absolutely. Thanks for having me, Jan. So lovely.
Yeah, pleasure. Bye-bye.
Bye.